The Lombardo versus Albu case had a significant impact on real estate transactions, particularly concerning the disclosure obligations of both buyers and sellers. Here are the key ways it shaped the industry. 1. Expanded disclosure responsibilities. The case reinforced the principle that both buyers and sellers have a duty to disclose material facts that could affect the transaction. While the case focused on the seller's obligation to disclose property defects, it clarified that both parties need to be transparent, and failure to do so can lead to legal consequences. 2. Non-knowledge disclosure. The court clarified that sellers are required to disclose material facts, even if they are unaware of those facts, provided they could have reasonably discovered them through an investigation. This principle of constructive knowledge significantly broadened the scope of disclosure obligations, making it clear that sellers must disclose any information that could affect the buyer's decision, even if they didn't personally know about it. 3. Legal recourse for buyers. The decision made it clear that buyers have the right to seek damages if they suffer harm due to non-disclosure of material facts. Buyers could potentially pursue a lawsuit for breach of contract or misrepresentation if they find out that the seller failed to disclose significant property issues or financial problems that could have impacted their decision to purchase. 4. Impact on real estate agents. The ruling also emphasized the role of real estate agents in ensuring that their clients, both buyers and sellers, comply with disclosure laws. Agents are now more diligent about ensuring that material facts are properly disclosed to avoid potential litigation. 5. Legal precedent. Lombardo versus Albu set a legal precedent for real estate disclosures in Arizona, reinforcing that both parties must act in good faith throughout the transaction. Sellers must disclose defects or material facts, and buyers must inform the seller of any financial or legal problems that may prevent the successful completion of the sale. The case strengthened the legal framework surrounding disclosure obligations in real estate transactions, ensuring greater transparency and providing buyers with legal recourse if they are harmed by non-disclosure. It also shifted how real estate agents approach their duties to ensure that all material facts are disclosed to avoid potential lawsuits. Mutual disclosure obligations are crucial in real estate transactions because they ensure transparency, trust, and fair dealing between buyers and sellers. Here are some reasons why these obligations are important, along with real-life examples. 1. Prevention of fraud and misrepresentation. Importance. Disclosure obligations protect both parties from fraud and misrepresentation. By ensuring that both the buyer and seller provide accurate and complete information, the risk of deceit or hidden information is reduced. Real-life example. A seller does not disclose that the roof of their property has significant damage. The buyer, unaware of the issue, purchases the home and later faces expensive roof repairs. Had the seller disclosed the roof damage, the buyer could have either negotiated a lower price or walked away from the deal, avoiding unnecessary costs and potential legal disputes. 2. Building trust between parties. Importance. Mutual disclosure fosters trust between the parties involved. When both the buyer and the seller disclose all material facts, it sets a foundation for mutual respect and cooperation, leading to smoother negotiations and a more successful transaction. Real-life example. A buyer is purchasing a home, and during the inspection, they discover mold in the basement that wasn't disclosed by the seller. Because the seller had failed to disclose this issue, the buyer might feel betrayed, potentially leading to a breakdown in the transaction or legal action. If the seller had disclosed the mold problem up front, the buyer could have considered it in their decision-making process or negotiated for repairs. 3. Avoidance of future legal liabilities. Importance. By fulfilling their disclosure obligations, both parties can avoid costly lawsuits or claims of misrepresentation later. This is especially important when one party's failure to disclose material facts could lead to financial loss or damages. Real-life example. A seller fails to disclose that a property is located in a flood zone. After the buyer moves in, the property suffers significant water damage during a storm. The buyer could sue the seller for damages caused by the seller's failure to disclose the flood zone issue. If the seller had disclosed the flood zone risk, the buyer might have chosen not to purchase the property or to take additional precautions. 4. Ensuring informed decision-making. Importance. Disclosure ensures that both parties are making decisions based on complete and accurate information. Buyers need to understand the financial, legal, and physical condition of the property, while sellers need to know whether the buyer can actually afford to complete the transaction. Real-life example. A buyer is relying on a seller's disclosure statement about the condition of the HVAC system. The buyer discovers after closing that the HVAC system is outdated and requires expensive repairs. The seller failed to disclose this issue, leaving the buyer with unexpected costs. Had the seller disclosed the HVAC's condition, the buyer could have either negotiated for a price reduction or budgeted for the repairs. 5. Facilitates smooth transactions. Importance. Clear and honest disclosures reduce the likelihood of misunderstandings or disputes during the transaction process. This helps ensure that both parties can proceed with the transaction without delays or complications. Real-life example. A buyer is purchasing a home with a specific financing requirement, such as an FHA loan. The buyer's agent discloses to the seller that the home must meet FHA standards. The seller discloses upfront that the property has some issues that prevent it from meeting FHA requirements. This disclosure allows the buyer to either adjust their financing or reconsider the property before moving forward, avoiding wasted time or potential financing issues at closing. 6. Compliance with legal and regulatory requirements. Importance. Real estate transactions are governed by laws that require both buyers and sellers to disclose certain information. Compliance with these laws is necessary to avoid legal penalties or the invalidation of the transaction. Real-life example. In a state like Arizona, sellers are legally required to disclose information about lead-based paint hazards in homes built before 1978. A seller who fails to provide this disclosure could face legal penalties if the buyer later discovers lead-based paint and sues. Compliance with disclosure laws ensures the transaction is legal and protects both parties from penalties. 7. Improving negotiation outcomes. Importance. When both parties are transparent about their positions, it helps to facilitate fair negotiations. Buyers can negotiate repairs, price reductions, or other concessions if they know about issues with the property. Sellers can adjust their expectations based on the buyer's financial ability or concerns. Real-life example. A buyer discovers during an inspection that the property has a minor plumbing issue. Rather than hiding this from the seller, the buyer discloses the issue and negotiates for the seller to pay for the repair or reduce the price to cover the cost of the repairs. By being transparent, both parties avoid future conflict and ensure a fair agreement. Mutual disclosure obligations are essential in maintaining fairness, trust, and transparency in real estate transactions. They help both buyers and sellers make informed decisions, avoid legal issues, and reduce the likelihood of disputes. By fostering open communication and ensuring that both parties are aware of all material facts, mutual disclosure leads to smoother transactions and a more secure real estate market overall. Managing unique transactional issues such as bankruptcy, financial troubles, job loss, or a buyer's inability to perform requires a combination of communication, empathy, legal knowledge, and creativity. By staying proactive, maintaining transparency, and collaborating with lenders and other professionals, agents can navigate these challenges effectively while ensuring both parties are protected and the transaction can proceed as smoothly as possible. Here are some final tips for real estate agents on managing unique transactional issues involving bankruptcy, financial problems, job loss, and situations where the buyer is unable to perform. 1. Stay proactive in communication. Tip: open and timely communication is key when dealing with any financial or personal issues that may affect a buyer's ability to perform. If a buyer has experienced a job loss, is undergoing bankruptcy, or facing financial problems, staying in close contact with them will help you better understand their situation and anticipate potential issues. Action. Regularly check in with your clients and document any conversations, especially when there are indications that they may be experiencing difficulties. This proactive approach helps identify any red flags early on and allows you to guide your client through potential solutions. 2. Educate buyers on disclosure obligations. Tip: ensure your clients understand their disclosure obligations regarding bankruptcy, financial difficulties, job loss, or other material facts that may affect the transaction. It's essential that buyers are transparent about their situation to avoid legal ramifications and potential contract disputes. Action: advise buyers to disclose any issues that could affect their ability to secure financing or perform on the contract. This includes notifying the seller and their lender about changes in their financial situation, e.g., job loss, bankruptcy filing, or significant financial setbacks. 3. Consult with lenders. Early. Tip: as an agent, you should collaborate with the buyer's lender early in the process when financial issues arise. Lenders can provide insights into how job loss or bankruptcy might affect a buyer's ability to secure financing, and can suggest potential solutions. Action: if a buyer loses their job or faces other financial issues, reach out to the lender immediately to understand how this might impact the loan application. Lenders may suggest alternative financing options, like a cosigner, or work with the buyer on extending deadlines. 4. Help buyers explore alternatives. Tip: if a buyer is unable to perform due to financial problems or job loss, help them explore alternatives to avoid losing the property or causing further disruption to the transaction. Action: suggest solutions such as delaying the closing. Sometimes a slight delay can give the buyer time to stabilize their financial situation or secure a new job. Assisting with down payment issues. Help the buyer explore down payment assistance programs or alternative sources of funding. Negotiating a contract amendment. In some cases, the buyer and seller may agree to revise the terms, including extending the closing date or adjusting the price to accommodate financial changes. 5. Understand and navigate bankruptcy and foreclosure laws. Tip: if a buyer is in bankruptcy or facing foreclosure, it's crucial to understand the specific legal nuances that might affect the transaction. Bankruptcy can delay or halt a sale, while foreclosure may introduce issues with clear title transfer. Action: advise the buyer to consult with a bankruptcy attorney to understand how their bankruptcy status affects their ability to purchase or sell real estate. Be prepared to work with the seller's legal counsel to ensure any foreclosure-related issues are handled appropriately, such as ensuring that a foreclosure sale is properly managed and doesn't derail the buyer's ability to perform. 6. Document everything carefully. Tip: in situations where the buyer is facing financial problems, job loss, or bankruptcy, make sure to document every communication, disclosure, and agreement between the parties. This documentation can protect you in case of any disputes or legal action down the road. Action: keep detailed records of all interactions with the buyer, seller, lenders, and other involved parties. Document changes in circumstances, disclosures, and the buyer's attempts to resolve financial issues. Clear records can provide critical support if the transaction is challenged or if a legal dispute arises. 7. Know when to advise the buyer to walk away. Tip: sometimes financial problems, job loss, or bankruptcy may make it impossible for the buyer to proceed with the transaction. In such cases, it's important to advise your client to consider walking away before further complications arise. Action: if it becomes clear that the buyer is unable to secure financing or meet the terms of the contract, suggest that they explore their options for termination of the agreement. make sure to review the contract carefully for contingencies that allow the buyer to exit without financial penalty, e.g., financing contingencies or inability to perform clauses. 8. Handle the emotional aspect with sensitivity. Tip: financial troubles and job loss can be incredibly stressful for buyers. As their agent, it's important to be empathetic and supportive throughout the process. Action: be a source of emotional support, listening to their concerns, while also offering practical solutions. Your ability to handle these situations with care and professionalism can make a significant difference in how the client perceives the transaction and their trust in you as an agent. 9. Collaborate with legal and financial professionals. Tip: when dealing with complex issues like bankruptcy, foreclosure, or financial distress, collaborating with other professionals such as attorneys, financial advisors, or foreclosure specialists can help provide expert advice and solutions. Action: encourage your client to work with the necessary experts, and in situations where legal or financial complexities arise, suggest that both parties, buyer and seller, seek legal counsel to navigate the transaction effectively and ensure compliance with laws. 10. Maintain a solution-oriented mindset. Tip: in difficult transactions where the buyer is unable to perform due to financial issues or job loss, maintaining a solution-oriented mindset is essential. Your role as an agent is to help the buyer and seller find ways to move forward, whether it involves negotiating adjustments to the contract or exploring alternative financing options. Action: focus on finding win-win solutions for both parties. For example, you may help the seller understand the buyer's difficulties and negotiate a new closing timeline, or assist the buyer in securing alternative financing to complete the transaction. Being proactive and creative can help salvage the deal and lead to a positive outcome. The buyer's agent is obligated to disclose that the buyer does not have the required down payment. Facts: the buyer and seller entered into a contract for the sale of commercial property, which requires the seller to finance $1,000 pursuant to a seller carryback. The purchase price is $150,000. The buyer is required to put $250,000 down pursuant to the contract, but does not have the cash to do so. The buyer is therefore going to borrow money from a friend to fund the down payment. Issue: is the buyer's agent obligated to disclose that the buyer does not have the cash for the down payment? Answer: yes. Discussion: here, the seller is financing $1,000 for the buyer as part of the transaction. The buyer's financial wherewithal is therefore material to the transaction. See AAC R428-1101B and Lombardo v. Albu 199 Ariz 99 14 P3D 288 2000. The buyer's agent is therefore obligated to disclose that the buyer does not have the $250,000 down payment. Buyer's loss of job should be disclosed reviewed. July 2016. Facts: the broker represents a buyer in escrow who just informed the broker that she recently quit her job as a teacher. The buyer still intends to complete the transaction with a $30,000 down payment towards the $55,000 purchase price, while financing the remainder. The buyer has some other sources of income, such as Social Security, but has not updated her disclosures to the lender. Issue: what disclosure obligations, if any, does the broker have? Answer: the broker may be required to disclose the loss of the buyer's job to the seller and listing agent, pursuant to AAC R428-1101B. 2. A real estate licensee is required to disclose in writing to all other parties any information the licensee possesses that materially or adversely affects the consideration to be paid, including anigh information that the buyer or lessee is or may be unable to perform. Accordingly, if the buyer is unable to perform in light of the job loss, that fact must be promptly disclosed in writing to the seller and seller's agent. Arizona Realtor or Magazine, April 2013. Disclosure listing. Agent must disclose seller's pending bankruptcy, regardless of seller's instructions. Facts: The seller is having financial problems, and his lender noticed a trustee's sale against the single-family residence. An agent listed the property for sale and ultimately procured a buyer for the property. Escrow is set to close before the trustee's sale occurs. The seller disclosed the pending foreclosure, and the buyer is willing to honor the contract regardless. During the inspection period, the seller advised the listing agent that in a panic he filed bankruptcy. The seller has instructed the listing agent to keep the bankruptcy a secret, claiming that his fiduciary duty includes a duty of confidentiality. Issue: is the listing agent prohibited from disclosing the seller's bankruptcy based on the duty of confidentiality? Answer: no. Discussion: an agent's duty to disclose known material facts trumps the duty of confidentiality. See Lombardo v. Albu, 199 Rs. 97, 14p, 3288, 2000. Additionally, an agent is required by the Commissioner's rule to disclose in writing all known material facts, including that the seller is or may be unable to perform. AAC R428-1101B1. The pending bankruptcy will affect the seller's ability to perform and therefore must be disclosed to the buyer.